Good morning. This is Patty Joe. It's been a while. I have to say that I have been struggling with some computer problems. Some of you have noticed some of my sound issues. I've been working on those. I had a complete crash of my system and my internet in my house. So that was a whole thing. And I have been under the weather, not feeling very well, going to the doctors, trying to get all of that sorted. So I really appreciate you. Really appreciate you spending time with me and some of my little hobby here. And I wanted to go back and take a look at Mr. Darrell Brooks and his 50-minute rant. Now, I know we've gone through this trial. I know this is all over YouTube. I know this is not a new thing, but I really just kind of wanted to jump back into things a little bit, easy and take a look at something we've all looked at and see if we can't piece out some things, that, he did. Hopefully I can get through this without getting too judgy. Let's go. This is just opinion. This is just my opinion. We know he has been convicted and so forth. I have not seen many new things, but again, I did not have internet for a while. So let's get started. Let's just go ahead. We'll try to breeze through some of the unrepeatable things we don't want to see.
All right, we are back on the record. Then appearances are as they were before. State have their next witness available.
Yes, Your Honor.
All right, let's bring the jury back out.
Don't consent to being called by the name that this court chooses to identify me by. I want to state for the record that I'm here as a third-party interviewer on special appearance on behalf of my client. Can that be noted for the record?
It was noted this morning.
May it be noted again for the record so that we can keep the record clear and accurate.
Why you don't keep the record clear and accurate?
The appearances are as they were this morning. They are no different. Bring the jury out.
And we have
So
yet
twisted.
to address subject matter jurisdiction, Your Honor. We still haven't. I still haven't been shown any verified
Yes, you have.
proof that
All rise.
this court has subject matter jurisdiction. And at this point, may I request an affidavit that you, Your Honor, have no bias, no conflict of interest, and no interest in the outcome of this case?
Mr. Brooks, the jury's coming out. We'll address your legal issues later, if I deem them appropriate.
Judge, do you hold the full
Mr.
judicial
Brooks,
power of the
please,
state, or is this the
please.
military
All right,
power?
Can you please take the jury out? Thank you.
Okay, so this is where this whole thing just spins in. This is going to go on for a while, so we might jump ahead a few because he just continues to argue and beat her down with his experience as a narcissist until she finally just relents and we get into the 50-minute rant. So let's see where we can jump ahead.
Do you hold the full
Mr. Brooks, just
jurisdiction?
wait till the
Oh my
jury's
goodness.
out, please.
He just can't. He
I ask that you
can't.
show that respect.
I will.
Thank you.
I'm going to go to headphones. Sometimes I forget I can hear better that way. Or maybe not. Pause. Go back. Okay, I think I might have got it fixed. I struggle. I'm sorry.
Name, nor do I consent to being called that name. Your Honor,
Your
with all
Honor.
respect,
With no respect.
merely asking you, do you have the full judicial power of the state, or is this military power?
I'm sorry? I don't understand what you're asking me, sir.
Because it's nonsense.
I'm asking, is
And on what
this,
legal basis are you making that request?
I'm asking for the record, is this a common law court or an admiralty court? What are we in here? And I'm requesting an affidavit that you, Your Honor, have.
Here, once again, I have to say, I have to chime in here because he has absolutely no idea what he's talking about. This is all some sovereign script that has been passed around. It has been published online or whatever it is that people do, passed around in jail. A lot of people try to twist these things around, but he has no history of having done this. When he was stopped on that porch, he did not invoke these ideas. When he was questioned for those days, he did not invoke these ideas. All the other times he was arrested, he did not invoke these ideas. At no time did he ever assert any of these beliefs prior to this. So he has no confidence in what he's saying whatsoever. And you can see, look how pale he looks. Oh my goodness. Looks ill.
No bias, no conflict of interest, or no interest in the outcome of this case. And the reason why I want to state this clearly for the record, mainly is because of the bias that's been shown. I have not been getting any certified copies of any requests that I've made, which I was told by this court to address inmate communication forms for anything that I may need. I've done that. I've complied with that. Every time I've needed something,
he thinks that if he thinks that the court is supposed to teach him how to do this and represent himself. He thinks that by getting these certified copies of whatever it is he files, that's his evidence. And he needed a lawyer.
of the court pertaining to documents, I've done it the way the court has asked me. And I've always stated that I wanted everything to be certified. I have yet to even get that. My court docket sheet was not a certified copy. When I asked Your Honor of your oath of office, I asked for that to be certified. You stated for the record that you would not give me a certified copy of your oath of office, which you are required to show if I ask for it. I've brought up my Sixth Amendment constitutional right that has been pretty much discarded, and that is based on the fact that I have the right to face my accuser, which would be the plaintiff, state of Wisconsin, in this matter. They have yet to show that a claim is I mean, a living human being can only make a claim. An entity cannot make a claim.
But
I've
those
requested
people that you harmed are deceased.
for the
Some of
complaint
them.
to be provided. The complaint from November 23 of 2021, the amended complaint from November 29th of 2021, the second amended complaint from January 12 of this year, 2022. I have yet to see those. There was no record of a bond in my docket sheet. I asked for that to be verified by proof. That hasn't been provided. There's so many biases, clear biases in questions that are not being asked.
He thinks if he says clear, if he adds some other word to it, that it's going to make it a stronger argument. And
Based on judicial determinations made by Your Honor. You look at the discrepancies, and I think they're clear. I think at minimum I deserve for the subject matter jurisdiction to be verified and proven. I've raised that issue numerous times.
It doesn't have to be, and she did it anyway.
I come before your court, Your Honor. I address that, and it has yet to be proven. My filings have been disregarded, even though they've been filed into the record, even though they've been time stamped. I haven't got the original copies of any of them, which I'm supposed to get.
No, you're not. You're supposed to keep them.
As
Keep
we
copies
sit
of
here
what
today,
you
I'm still not even understanding the nature and cause of the charges. That hasn't even been proven. Can that be provided in any way? I'm basically sitting here confused because I don't understand why these proceedings are allowed to continue when there's so many things that
When I
have
don't
not
want
been
them
provided.
to.
They haven't been provided in my discovery. They haven't been provided to me by being brought to my pod where I'm housed in the jail. I'm without so much information, valid information to this matter. And I believe that it should be verified and it should be proven for the record. And if not, I move for this case to be dismissed for failure to appear by the plaintiff and failure to state a claim for which relief can be granted. Everything that I'm
Those
saying
are civil arguments.
has merit and it has validity.
Issue. Well,
As
I
we
don't
sit
know.
here
Somebody
today, I'm
who's
still,
got law experience
being
explain it to me.
charged with charges that shouldn't even exist based on the testimony that we've heard for the last few days. There's so many things left to still be proven. The prosecution
Okay,
team
well, that's why the trial is
hasn't
still
even
going on.
proven that they're licensed to practice law in Wisconsin. They haven't proven, are they just
The only one not licensed to practice law in Wisconsin is you.
bar association members, or do they have state issued licenses? That has not been proven, which I've raised that issue for the record. I'm not even sure if that was even recorded in the docket sheet. There's so many things, and Your Honor, you still haven't stated for the record if you have full judicial power of the state or is this military power. That hasn't been proven. Nothing has been proven. Not subject matter jurisdiction, not licenses to practice law. My Sixth Amendment right has been basically trampled over. No complaints have been shown. Neither of the three that I've requested, by the way that you told me to request them by inmate communication. Nothing is certified that I get copies of when I clearly asked for them to be certified and to be filed into the record. It's to the point where Your Honor, you should recuse yourself from the presiding at this point. If you're not going to abide by the oath that you swore, which was in your oath, correct? You swore
Glad that
to
they're all
protect
silent.
the Constitution of the United States. You swore to protect we the people. That is not being done here. If every valid argument that I raised is taken by the court as a sign of disrespect or a sign of trying to intentionally be disruptive or causing a problem, when I'm merely seeking understanding because I don't understand. I'm merely seeking to understand why this information has yet to be provided and we're this far into this matter. And there's still no verified proof. Even as I sit now saying this, there's still no proof being provided. Zero. How is this case allowed to continue without these documents and filings being verified? Is there any
Because it's
legal
all
factual
nonsense.
basis that can state why this information has not been provided? Why the docket sheet is incorrect? Why there's so much on the
According to
docket sheet
who?
that should be on record that's not even in there? That if we had the recordings of the record they received was brought up numerous times that doesn't even show up? I'm just asking for Your Honor to be fair which is another right that I have, the right to a fair trial and the right to an impartial jury. I can go on and on and on about what's not being done. I have, again, I say I have the right to face my accuser. Where's the injured party? Who's making the claim? I asked Your Honor numerous times for Your Honor's name. You wouldn't answer. I asked, did you have a claim against me? You did not answer. I asked the whole courtroom, did anyone have a claim against me? No one said anything.
Because it's
Which
a
you
meaningless
stated for the record,
statement.
a non-responsive answer is an agreement, which will be a tactic agreement by you, Your Honor, that you don't have to answer
Saying that
these
wrong.
questions that you should be answering.
Even I know that.
I have that right. The plaintiff in this matter, which was stated by witnesses in testimony to be the state of Wisconsin. But when I asked, do they see the state of Wisconsin present in the courtroom, the question is shut down, which is a valid question.
It is not a valid
should be
question.
present in this matter. Where is the plaintiff? Who's
Dumb Darrell. Okay, Darrell. Let me just look at you right in your beady little dead eyes and say this. The state of Wisconsin represents the people. We all subscribe to a social construct with rules and regulations. Lots of those are very basic. You know, don't steal from people. Don't harm people. Don't take away their lives. You did all of those things, or you're being accused of them at this point, but we all know that eventually you're convicted. So the state of Wisconsin being represented by the offices that we put together to represent us as a people, we all have been harmed. Well, Wisconsin basically, but we all have been harmed by his toxic person. So they are there, every single person, and the accusations have been read to you, and they are understood by you. Otherwise, you wouldn't be making these twisted and incorrect but sophisticated arguments. Moving on.
who's bringing the claim? Because we know an entity can't bring a claim. It has to be a living, breathing human being. No one is stated for the record if they're the injured party. Not Your Honor, not the prosecutors, not anyone in the court has stated to be an injured party in this matter. No one. Not one person. I have the right to demand that the court place in the evidence any unrevealed contract.
What? Just somebody help me out with that one.
Provided to me, have that been placed in the evidence? I would like to see it, which is my right. I have the right to inform the jury about the truth in their duty, in their rights. That's the First Amendment and the Sixth Amendment. But I'm repeatedly told to shut the question down when this is valuable information that the jury should be privileged to know. They deserve to know. Once they were chosen to sit on this jury, why are we keeping information away from them that they deserve to know? They ultimately have the power. They decide the matter. Why are we keeping information, valuable information, from their knowledge? That's a disservice to.
You're very selective about that, Darrell. Darrell, you don't want them to know how abusive you've been for the past 20 years to the same person that you basically picked and, I guess it's far enough, and groomed for her whole entire life until you have twisted it where she had no background and no basis and solid ground to bring her back from those harms that you did to her, all of the people that you have harmed, even in the month before you committed this atrocity, towards your family, you know, and you just think you can do anything you want. Oh, I'm off track now too. I'm just gonna let it go.
The jury. And frankly,
They're not
it's a
going to let you go just because
disservice
you
to the
want them
court
to.
that they're not allowed to hear things that they should know, that they should be informed of.
I don't
It's
think
our
anybody's
right
that dense.
to inform them of everything that they have the power to know, to do, and to know.
You
They
want them to know what
deserve that
you want them
much.
to know.
It would be a travesty for them to make a decision
But not about your past
without being fully
convictions.
informed. And these
Well,
are
they're not
all
going to.
valid things. I have the right to protest and object if any of my rights or demands are not being met. I've done that numerous times only to be shut down. Numerous times. I've raised the issues that I didn't consent to anything that may have been suggested on behalf of my former attorneys. I've never even consented to them making a plea on my behalf. I haven't, as a matter of fact, when it comes to a plea, I haven't even had the opportunity to entertain any plea that may have been suggested by the prosecution. We haven't even talked about that. Not one time was it ever brought to my attention that the prosecution even wanted to offer a plea. That's another issue. I have the right to challenge the jurisdiction of this court, which I've done numerous times. I have the right to demand that the code be construed in harmony with the common law. I just raised that. I'm constantly referred to as pro se when I've raised the issue that I'm pro per. I have the right to conduct my defense pro per, free from professional restrictions imposed upon licensed attorneys, which this court is well aware that I am not a licensed attorney. In fact, the court is.
So he's just made an argument that contradicts the other argument that he made at the very first, which is, why isn't anybody showing me their credentials and their licensure? And now he's arguing the other side of that. He talks out of both sides of his mouth to try and make him give himself some kind of.
Also aware that I only had 3 days to prepare for a trial
No, you
that
didn't.
the
You had a year.
prosecution has been prepared for a whole year. We see these boxes right here. This box alone is 45 or 50 pounds.
So
much information. I haven't even gone through half of it.
So
It was stated for the record that the discovery, in its entirety, was brung to my housing unit on the 29th of September.
Even I'm not that bad with my English.
Which trial was scheduled, that would be a Thursday, which trial was scheduled for Monday. How can I possibly go through all that, all the paperwork, all the digital discovery and things of that nature? How can I go through all of that and be prepared in 3 days? That's a clear bias. I did not have time to prepare for this. Everything I'm doing is off the top of my head, winging it, taking it as it comes. When the court is well aware that I was not prepared, I raised the issue that it should be an adjournment, at least at the minimum, it should be an adjournment because of that fact, at least to let me go through all the discovery. That was denied. No valid reason
Because
was
somebody
stated
went
for that,
over it
and
with you the
Your Honor
whole
knew
way.
there is no possible way, humanly possible, that I could be ready for a trial of this magnitude.
He had those attorneys the entire year. There is no way they did not go through each and every piece of all of this discovery with him prior to him letting them go and representing himself pro se, pro per, which, by the way, is, according to what I understand, is the same legally. he'll eventually talk out of the other side of his mouth and say, this went too fast, and then my right to a speedy trial was denied. So he'll try to argue both sides of that coin too, which is ridiculous.
In 3 days.
In 3 days.
That's
Oh
clear
my
bias.
gosh. It's not bias. That's not what
I have
bias
the right
means.
to face the injured party claiming damages. That's under
Here we go
Article
again. This
3
is like
and
the
6th
fourth
Amendment.
time he's brought
I
that
raised
up.
that issue again. Where's the injured party? Is the injured party present in court right now? Can anyone make a claim against me? Can you make a claim against me, Your Honor? Do you
Everybody
know
in
of anyone that can
Wisconsin
make a
can.
claim against me, Your Honor?
The people.
Can anyone right now in court, anyone, make a claim against me?
The guy behind him's got to be sitting on a thumbtack. That's the only way. There's no way.
And because of that, Your Honor, the motion to
Oh my
dismiss should
gosh.
be granted based on that alone. There's no injured party in this matter. So who makes the claim?
What do you mean there's no injured party?
I have the right to put the judge on notice of my intent to appeal in any ruling decisions during the case. You stated for the record that I would have to wait until appealing process, but my right is that I can raise that issue during the case, which I've attempted to do. That's been shut down. I have the right to specifically reserve all of my rights, which I do at the beginning. I have the right to say what I want and to be heard under the First Amendment. And when I
No.
attempt to do that, it's taken as a slight to the court, a disrespect to the court, or me intentionally coming into the court to be disrespectful, which I've stated that is not my intention. Never is it my intention. I never intend to walk into.
He doesn't
your
know what
courtroom, Your Honor,
respectful
and be
means.
disrespectful intentionally. I never come into this courtroom to disrespect anyone. But because I don't understand, I raise these issues because they have validity. I have the right to object to any statement made by the judge or the prosecution. I've done that and been repeatedly shut down. Without a lawful explanation. I've repeatedly asked the court for a motion for a finding of fact to determine if things are being done legally. I've been denied that numerous times without merit, which is also my right. I have the right to recuse the judge at any time.
No, you have the right to
Which is
request
also
it.
a right.
But there is a limit to that too.
I have the right to a speedy and fair trial
Here we go.
by impartial jury. I think it's safe to say that my speedy trial right has definitely been violated because this matter has been taken
But what about, you only had 3 days. You only had 3 days and now you want it speedy.
in place for
Oh,
roughly a year. I've never consented to waiving anything related to a speedy trial. And if that was done, it was done without my consent or without my knowledge. We're way past the speedy trial date, way past. When the change of venue motion was brought up, I believe that was the first time I came before Your Honor in early March. I want to say March 11th of this year, when the change of venue motion came into play. It was decided by Your Honor that wouldn't be decided until the 20th of June, I believe. That's over the 90-day mark right there for a speedy trial.
but that was your motion from
That
your
was-
side.
denied, and I still don't understand how that was denied.
There is not one place on this earth with people so out of touch that they would not have come to the same conclusion. Sorry, Darrell.
When it's clearly obvious that
Clearly obvious.
at minimum
Again,
the venue should have been changed based on the fact of the magnitude of
because
the
he
matter.
wanted it.
There's
the
no
magnitude.
possible way anyone in this county would not have some type of connection or some type of knowledge, whether they were
Rather, they were what?
told something by someone that they may know. The news reporting alone, just that alone, there's no way that this trial should be taking place in Waukesha County. That's obvious. That's obvious from the way the motion was presented, the coverage alone, the political campaign ads that plastered the defendant's face all over the
Defendant.
TV every
That's you.
single
You
day.
didn't say
Every
alleged.
time
Oh my gosh.
A political campaign was brought up, it made reference to this incident. Every single time. The fact that people have children that go to the same schools in this county, that people may have worked with the same people in this county. You yourself, Your Honor, stated that you at one time worked with the father of one of the people that was injured in this matter.
I don't know what the population of Waukesha was at the time or is right now. But basically, when you run over 70 people in a small town, the chances that there's related people in the area go up very quickly. Darrell. Stupid.
That is a clear conflict of interest right there. You also stated for the record that not only did you work with this father, but that at one time they may have donated to your, I don't know if it was to you becoming a judge or I will have to look through the docket, but you said it on the record that they donated money to a cause of yours. You also stated that when you had gained knowledge of the incident and that their family member was injured in the incident, that you reached out via phone. I don't recall if it was text message or an actual phone conversation, but you put that on the record. You also stated that the nature of your relationship was strictly professional. I don't know about you, Your Honor, but I've worked numerous jobs and I know what professional relationships is.
I can't even let him finish his statement. Sorry. No, Darrell. A, you don't have friends. B, you don't have professional connections or relationships with people because you've never really held down a job. Okay, you've always been a scam artist, criminal element, just seething at the bottom of the ilk. And believe me, I have seen ilk.
In personal relationships. I've never had the cell phone number of anyone that was a personal relationship.
I don't know anybody who would give you a cell phone number, Darrell.
That would constitute a personal relationship of some kind. Whether hanging out from time to time, having a cup of coffee, or
using
hanging out
incorrect
time
words.
from time, grabbing a beer, or hanging
He
out
just
from
bothers
time to
me.
time, watching a game, or anything of that nature. It would definitely be more than just strictly professional. That was stated for the record. Again, I go back to the Sixth Amendment again.
Oh my God. This is like the fifth time?
In terms of when
we needed
I
to
asked
take
for
a shot every
the
time.
the motion for the evidence motion that I raised, that was denied without any explanation. that would be strictly to place in the evidence any unrevealed contract. That's under the
Meaningless.
Sixth Amendment.
Meaningless in this case.
Clearly, there's been repeated violations of my Sixth Amendment. We all know that the United States Constitution is the law of the land, period. It trumps everything.
No.
We also know that any law repugnant of the
Repugnant.
Constitution is null and void.
An
We know
invoid.
that.
Oh, he's so uneducated. He needed help. He's worse than I am. I have difficulty with these things. These are high-level things.
No basis for the motions being shot down.
My sisters are a lot smarter than I am.
Why was
but
I not granted the motion for finding a fact? Why did it take so long for me to be brought my entire motion for discovery? Why was the motion to prove jurisdiction not verified? Why was the motion to dismiss the case for all the reasons I said not being granted?
Because there's no lawful
Which
reason
brings
to
me to the motion to
dismiss.
subpoena witnesses. I did everything that was asked of me by the
No,
court
you didn't.
pertaining those subpoenas.
No, you did not.
It was understood by the court that this is my first time ever having to do this. I didn't understand how to properly
Obviously.
fill out the subpoenas, at which the prosecution volunteered that they would give assistance.
You were
The only
ungrateful, like a
assistance I received was
narcissist.
for them to check to see if it was filled out right. That was it. That doesn't amount to any assistance. I was still left to fill it out on my own, and then when I did that, correction still had to be made, which would verify what I was saying. I don't know how to do this. But I still complied to what the court asked of me. And even then, it was a big old thing about the subpoenas. I can't subpoena the plaintiff in the case. Well, how can I not subpoena the plaintiff in the case when under the Sixth Amendment, I have the right to face my accuser, which is the plaintiff of the case? So how could the subpoena not be filed? And how could the plaintiff not be called to the witness stand? That begs the question of, does the plaintiff even exist? Which it was stated for the record that not only by
I wish we could skip over this and not ruin the integrity of the
that got on
whole
the stand and said
rant.
on the record that is an entity, which is not a living, breathing human being. And then it was stated again by you on the record, Your Honor, that the plaintiff is an entity. So the question still stands. How can an entity bring a claim if it's not a living human being? So where's the claim? Will the plaintiff in this matter, the state of Wisconsin, be allowed to testify? Would they be allowed to be in the courtroom?
No, they were bringing witnesses.
No, they will not, because they don't exist. Therefore, the claim doesn't
They
exist.
exist. They exist.
For all those reasons that I just stated, the case should have been dismissed a long time ago. Once those issues were raised, this case should have been dismissed.
Okay.
And at the very minimum, it should have been dismissed because those still have yet to be proven. We're still talking about jurisdiction. That's been being asked for over a week. There's still no providing of license to practice law yet.
Oh my God. Are we going to repeat now?
Not even by you.
Please
Your
tell me
Honor.
we're coming to the end. No, we're not even close. We're only halfway through. Oh.
Why was I not provided with a certified copy of your oath of office?
Oh, again. Oh, we're repeating. Oh my gosh.
Why would you not state the name that is on file with the Secretary of the State, or I made reference the first time to the Secretary of the Treasury, and then you stated on the record that it's the Secretary of State, even though you knew what I was referring to when I asked. You referred to your name tag, but that's not the name registered. We both know that. So why wasn't that proof verified? You gave me a copy of your oath of office, but it's not certified. So how can I verify that that is the true oath of office that you signed? How can I verify that it's valid? That's the reason why I asked for it to be certified, which you stated for the record you will not do that. You never stated any
This might have to be 2 parts.
legal reason why.
Okay, this is going to have to be 2 parts, because I believe now what we're doing is we are going into the part 2, going right back to the beginning, because this is the very first things he said. Subject matter jurisdiction, her oath of office, her name. We'll probably be going all the way back through it. So we're going to break this down into 2 parts, because this is harsh. This is super harsh. So I'm going to break it off here. I'm just going to say this guy is really trying to just spin it, get the case dismissed, let me go home, give the jury the power to go home. All of these things he's saying, talking out of both sides of his mouth. He just doubles down, triples and quadruples down. So we're going to leave this as part 1 right now, and take a look at part 2 after I take a break and maybe have a glass of water. Again, I hope everybody out there is healthy. I have not been feeling that healthy, so I'm trying to get myself together. Thank you for Fox 9 News. Thank you for your patience. I'm going to try to do a couple of more videos this week. I've got, catching up with my family to do, all those things, a lot of doctor's appointments, things like that. So please keep yourselves healthy. I might put up some motorcycle videos or some videos of my puppy. So I hope you enjoy those as well. Just, make yourself happy. Make yourself happy. And have a great, great day.